Hi, today I'm going to talk about the whaling case, law, politics, and the future of whalings. In whaling in Antarctic Australia against Japan, the New Zealand intervening, the International Court of Justice gave its judgment on 31st March 2014. The court decided that Japan's JAPA 2 whaling program didn't meet the rule in Article 8, subsection 1 of the International Convention for the Regulation of Whaling. The rule says that countries can only give special permits for whaling if it's really for purposes of scientific research. The ICJ agreed that using legal methods for research is not automatically illegal, but by 12 votes to 4, the judges found that JAPA 2 wasn't properly explained or justified. The sample size, methods, and overall designs were not reasonable for the goals of the program. Because of this, the court said Japan had broken Article 8, subsection 1, and also several ICRY schedule rules, like paragraph 10 subsection A, zero catch limits, paragraph 10 subsection D, the ban on factory ships, and paragraph 7 subsection B, the Southern Ocean Sanctuary. As a result, Japan was ordered to cancel all JAPA 2 permits and not issue new ones. The court also looked at jurisdiction. Australia relied on Article 36 subsection 2 of the ICJ statute. Japan argued that Australia's reservation excluded cases about marine living resources. The ICJ rejected this argument and confirmed it had jurisdiction to interpret the ICRY. The court also refused to make any ruling on Antarctic sovereignty, in line with Article 4 of the Antarctic Treaty, which freezes territorial claims. This careful step made sure that the case stayed only about whaling regulation and didn't affect the sensitive Antarctic treaty system in the short term. The decision had a strong effect. Japan stopped its Antarctic whaling for the 2014 to 2015 season and cancelled all JAPA 2 permits. In the longer term, however, the effect was limited. Japan quickly began a new program, NIVREP A, with smaller quotas and a mid-term review, and claimed it met the court's requirements. Flip Claflin argues that this response shows Japan's long-standing strategy of adapting its program so that whaling can continue under the level of scientific research. Other commentators point out that while the ICJ made clear that Article 8 cannot be used as a cover for commercial whaling, the court cannot fully prevent a determined state from continuing whaling under a new plan. Academic writers have also looked at the wider meaning of the case. A major point is that the ICJ carefully reviewed the scientific methods used in JAPA 2. Instead of simply trusting Japan's experts, the court looked at the design and justification in detail. This created a standard of reasonableness and transparency for scientific research exceptions in environmental treaties. Some scholars praised this, while others found that the court might have gone too far into judging science itself. Another issue is whether states should have wide freedom in deciding what counts as scientific research or whether international law should give a stricter review. As Shirley said, it's surely not that the judgment showed the ICJ's willingness to step more deeply into assessing the scientific basis of state conduct, while at the same time avoiding political issues such as sovereignty in order to keep the case focused strictly on whaling regulation. Overall, the case is seen as the most important judgment against scientific whaling. It confirmed that Article 8 must be used in the good faith and supported by real scientific reasons. At the same time, it showed the limit of international courts. They can clarify the law and create political pressure, but they cannot completely stop a country from reshaping its actions within the wording of the law. The case is therefore both a landmark in environmental treaty interpretation and a clear example of the difficulties in enforcing international conservation rules. Hi, this presentation, I'm going to talk about Australia's position on the legality of Russia's armed conflict with Ukraine. Russia's full-scale invasion of Ukraine in 2020 broke one of the clearest rules of international law. The UN Charter in Article 2, subsection 4, says that countries cannot use force against another state's independence or borders. In simple terms, big powers are not allowed to decide the fate of smaller countries by military aggression. That's the basic principle, and it's the reason Australia reacted the way it did. From the beginning, the Australian government called Russia's invasion a gross violation of international law. Foreign Minister Penny Wong stressed at the United Nations Security Council in 2023 that larger countries shouldn't be able to determine the fate of smaller countries and that no nation is above the UN Charter. According to the Department of Foreign Affairs and Trade, Australia has framed its support for Ukraine as defending the so-called rule-based international order. What that means is, even powerful states should follow the rules, not just rely on force. This is also why Australia joined sanctions, spoke up at the UN, and lined up with allies like the US and Europe. But if we look at what Australia actually provided, the picture is a bit more modest. As Dr. Lavin Lee pointed out in International Politics, Australia is acting like a middle power ally. That means it stands strongly with its partners, but its ability to change the outcome of the war is limited. In total, the government has pledged around 1.5 billion Australian dollar in military and humanitarian aid. That sounds big, but in the scale of a war like this, it's not huge. On the military side, Defence Minister records show Australia sent 120 Bushmaster vehicles, some M113 armoured carriers, and a few Abrams tanks. According to the Lowy Institute, these are important, but more symbolic than decisive. Bushmasters are excellent vehicles, but 120 of them won't turn the tide of the conflict. On the humanitarian side, Australia has issued around 15,000 visas for Ukrainians fleeing the war, according to the Department of Home Affairs. That's meaningful, but again, small when compared to with the millions hosted by countries like Poland or Germany. Scholars in international affairs note that this is typical of Western responses. Each country does a bit, but middle powers like Australia can only do so much. So, how do we make sense of this? Scholars generally argue that Australia's support is symbolic rather than decisive. It shows solidarity, strengthens alliances, and sends a strong message that aggression can't be tolerated. But on its own, it doesn't change the course of the war. In that sense, Australia's aid works more as a political signal, a way to stand with Ukraine, show loyal to allies, and defend the idea of a rules-based order. And there is another angle too. Australia often presents itself as an environmental leader, but we saw this in the whaling case against Japan that was all about protecting whales and defending the environment. But when we look at Ukraine war, the weapons Australia sends, like Bushmasters and tanks, also carry a heavy carbon footprint. They run on fossil fuels, they create emissions, and they contribute to climate change. So just as its military support is symbolic rather than decisive, we might also say Australia's environmental image is symbolic. On the one hand, it promotes itself as green and protective of the oceans. On the other hand, it takes part in a war effort that increases emissions. That doesn't mean the sport is meaningless. It matters politically, but it shows that both Australia's aid and its green reputation operate more on the level of symbolism than on real transformative impact. To finish, both the Whaling case and Australia's role in Ukraine show us that international law can send strong messages. But it cannot always change what countries decide to do. Australia's actions are important for showing support and standing by its allies, even if they are more symbolic than decisive. In the end, symbolism still matters in international politics.